The antipathy to advisory opinions and the standing, mootness, and ripeness doctrines also reflect a core feature of the Anglo-American legal system. Ours is an adversarial system rather than an inquisitorial one. When you take your professional responsibility course, you'll learn that one of your most basic duties as a lawyer is to represent your client zealously. This is not your only duty. You have duties to the court and even duties to your adversary. Moreover, the duty to represent your client zealously is not a license to use any means to reach any ends your client might desire. Zeal is a concept cabined by your broader responsibilities as a member of the bar. Nevertheless, as a lawyer, you represent your client, not the other side. In the litigation context, if there's no genuine dispute for which a court can provide a meaningful remedy, there's no adversity, no case or controversy, and as a constitutional matter, the court lacks jurisdiction to hear the case. There are also circumstances in which a court might technically have the power to hear the case, but might choose not to do so for prudential reasons relating to judicial resources or related concerns. Because of the gatekeeping role these doctrines play in our adversarial system, you should always keep them in your mental checklist of things to consider when you first assess any legal problem. That includes exam questions in this class, but it also includes your work for clients. In a litigation context, as a practical matter, you should always ask, what is the remedy here? And what is the basis for the court to hear this claim? Thinking about remedies at the outset of a matter will help you work through any potential issues relating to standing, mootness, or ripeness. And it will also help you think about what the claim is really worth at the end of the day. Remember, your clients usually don't care about interesting but arcane constitutional doctrines. They want a concrete remedy or practical advice about their exposure and how to mitigate it. At my prior law firm, one of my colleagues used to say, "A procedural win is better than a win on the merits any day." That was very much a defense lawyer's perspective. What he meant was that getting a case dismissed on procedural grounds, whether on a seeming technicality in the rules of civil procedure or on something that's really more substantive, such as standing, usually happens early in a case, before the client has incurred major expense and before any dirty laundry is aired through discovery. From a plaintiff's perspective, the flip side of this is that thinking through these preliminary matters well before the case is filed will give you a better chance at a hearing on the merits and/or a more favorable settlement. Remember also that court dockets are bursting at the seams and that judges A, are happy to find reasons to get a case off the docket, and B, are not happy when cases are filed prematurely or improperly. This isn't to suggest courts will neglect their responsibilities to decide cases, not at all, but just to note some of the practical realities that intersect with these doctrines. So, on to the doctrine. I'll offer a few thoughts on our main cases in a moment, and we'll discuss them in depth when we meet in person. You should distill from these cases the following principles and rules. First, distinguish between constitutional and prudential standing. The court has characterized constitutional standing as an Article III requirement, meaning that federal courts lack jurisdiction to hear a case unless the requirements of constitutional standing are met. Prudential standing, in contrast, relates to certain categories of cases in which the black-letter requirements of constitutional standing might be met, but the court has set some kind of more or less clear line about the use of judicial resources. Since constitutional standing is a requirement of Article III, it cannot be negated or waived by Congress. Judicial rules about prudential standing, on the other hand, relate more to judicial administration than constitutional doctrine, so Congress could create different rules. For constitutional standing, the following test drawn from the Lujan case is a good summary. There must be 1, an injury in fact, that 2, is fairly traceable to the defendant's action, and that 3, is redressable by judicial action. As you can see, this is a conjunctive test, meaning that each element of the test must be satisfied. For the first element, injury in fact, the injury must be concrete and particularized and actual or imminent, not conjectural or hypothetical. For the second element, the injury must be fairly traceable to the challenged action of the defendant and not the result of the independent action of some third party not before the court. You can think of this as a causation requirement. For the third element, it must be likely as opposed to merely speculative that the injury will be redressed by a favorable decision. For prudential standing, you should check whether the issue you're considering falls into one of several categories of cases in which the court has imposed prudential limits on the exercise of jurisdiction. These include 1. Claims on behalf of third parties, 2. Generalized grievances by all citizens or taxpayers alike, and 3. Claims by plaintiffs who are outside the so-called zone of interest protected by the Constitution or a statute. As the notes in the casebook suggest, you should be a bit careful with these categories. There are some kinds of third-party claims that are specifically authorized by statute, as well as some kinds of general third-party constitutional claims the court has allowed, particularly where the immediately injured party is unable or unlikely to pursue a claim. I've emphasized the gatekeeping role of standing and related doctrines in these comments, which might give the impression that these are difficult barriers for plaintiffs to overcome. In fact, in the run-of-the-mill of cases, these threshold issues are obviously met and not even litigated. In general, the plaintiff must only allege that this defendant caused this specific harm to me through these actions, for which the court can provide this remedy. If the claim is for breach of contract, for example, for standing purposes, it's sufficient to allege that plaintiff and defendant were parties to a contract, defendant breached the contract, and plaintiff suffered certain monetary losses as a result of the breach. Of course, the plaintiff must still establish other aspects of federal jurisdiction, such as the amount in controversy and diversity of citizenship requirements if this breach of contract claim is in federal court only on diversity grounds. As an example involving a federal question, in a patent infringement case, for standing purposes, the plaintiff need only allege that it is the patentee or exclusive licensee under the patent, that the defendant infringed the patent, and that the plaintiff suffered damages under the Patent Act as a result of the infringement. Note that I use the words allege here. The basic question of standing, if it is an issue to be litigated, usually arises at the beginning of a case in the context of a motion to dismiss under Rule 12b-6 or a motion for summary judgment. As you know from your civil procedure class, under Rule 12b-6, the factual allegations in the complaint generally must be taken as true, and a summary judgment motion should be denied if there's any issue of material fact. This means that, in typical cases, issues of standing usually arise only when it appears that the claim has been brought by the wrong plaintiff. Taking patent litigation as an example again, only the patentee or an exclusive licensee of the patentee has standing to sue for infringement because these parties are the owners or beneficial owners of the property-like interest in the patent grant. A non-exclusive licensee, in contrast, only has a contractual right to make, use, or sell the patented invention for some limited purposes. A non-exclusive licensee may indeed be harmed by someone else's infringement of the patent, because the infringer might eat up some of the non-exclusive licensee's potential market share. But the proximate cause of that harm is really the patent owner's actions or inactions in relation to policing its patent against infringement. It's easy for a non-exclusive licensee to negotiate with the patent owner for terms that cover the possibility of third-party infringement. Such terms might involve, for example, a contractual obligation by the patent owner to enforce by initiating infringement litigation, a refund of or reduction in royalty payments, a right to walk away from the license, or many other kinds of business terms between the patent owner and licensee. Courts have therefore held that non-exclusive licensees under a patent lack standing to sue an infringer. It's not uncommon, however, for a non-exclusive licensee to attempt to initiate a patent infringement claim, leading to a motion to dismiss for lack of standing. Even here, there are some complicated cases in which courts have to decide whether a supposedly exclusive license really is exclusive or non-exclusive. These observations help put the principal cases in this unit into context. Notice that the Lujan and Massachusetts v. EPA cases both relate to environmental protection statutes. Why do you think that this kind of environmental litigation might raise standing questions? Notice also that, although Lujan was a 7-2 opinion, it produced some disagreement among the majority about the doctrinal and policy implications of finding a lack of standing for the plaintiffs before the court. Massachusetts v. EPA, decided in 2007, resulted in an even more fractious court, with a vote that broke along ideological lines, including Justice Kennedy as a swing vote for the liberal bloc, holding that the petitioner did have standing to bring its claim. How do you think the different results and different written opinions in these cases relate to the justices' views about the regulatory state, and specifically about environmental protection regulation and the EPA. When we discuss the commerce power in Units 3 and 4, we'll talk some more about how the growth of the regulatory state relates to the constitutional separation of powers. Is standing doctrine an appropriate tool for calibrating the power of regulatory agencies? As you ponder this question, consider this additional background information relating to the Massachusetts v. EPA case that is not part of the excerpt in our casebook. First, some very general background on the administrative state and administrative law. The Constitution mentions only 3 branches of government: the legislative, executive, and judicial. So where do administrative agencies such as the EPA fit in? Usually, such agencies are organized under the executive branch. Congress lacks the expertise to issue detailed rules in many technical areas, such as environmental protection. Further, as circumstances and technology change, such rules must frequently be amended. There's a need for a kind of speed and flexibility in the legislative process cannot supply. Congress therefore creates a basic legislative framework and delegates authority to an administrative agency to conduct detailed rulemaking under that framework. Again, we'll discuss this further in Units 3, 4, and 5, but for now, note that the modern court generally has upheld Congress's ability to make such delegations to administrative agencies housed in the executive branch. As an aside, you may have heard that one of the major fault lines in the confirmation of Judge Brett Kavanaugh to the Supreme Court relates to his views about the Chevron doctrine, a rule of deference to reasonable agency interpretations of the scope of legislative delegation announced by the court in the 1984 case of Chevron USA v. National Resources Defense Council. The issue of Chevron deference will be covered in detail if you take a course in administrative law, and other aspects of the interaction between Congress and the administrative agencies are covered in a separate course on legislation. One of the big issues raised by the growth of the administrative state is the question of democratic accountability. There's theoretically at least a broad form of democratic accountability over executive branch agencies, in that they are accountable to the president, who is accountable to the voters. But that very broad sort of accountability does not really address what say, if any, the public has in specific rules an agency might adopt. To address this concern, in 1946, Congress passed the Administrative Procedures Act, the APA, which provides procedures for public notice and comment relating to proposed agency regulations. The APA also requires federal agencies to give interested persons a right to petition for issuance, amendment, or repeal of a rule, and some environmental statutes include specific provisions for this kind of petition. The United Nations International Panel on Climate Change, IPCC, issued its first comprehensive report about the link between human greenhouse gas emissions and climate change in 1990. In 1999, a group of 19 private organizations, including environmental advocacy organizations and alternative power companies, filed such a rulemaking petition with the EPA to regulate greenhouse gas emissions from new motor vehicles under the Clean Air Act. In 2001, during the notice and comment period for this proposed regulation, President George W. Bush requested a report on global warming from the National Research Council, an arm of the National Academies of Science. The NRC endorsed the findings of the IPCC, although it noted that a causal link could not be unequivocally established. In 2003, however, the EPA, under then-Director Christine Todd Whitman, the former Republican governor of New Jersey, appointed as FDA chief by George W. Bush, denied the rulemaking petition. The grounds for denial were that 1. The relevant statute, the Clean Air Act, did not authorize EPA to issue mandatory regulations to address global climate change. 2. Even if EPA had such authority, it would be unwise to exercise it because the causal link between the human activity and climate change could not be unequivocally established. After the rulemaking petition was denied, the private organizations, joined by a number of state and local governments as interveners, sought review of the rulemaking in federal court. A panel of the D.C. Circuit Court of Appeals, in a 2-to-1 opinion, denied the petition for review, and the Supreme Court took certiorari. The excerpt in our casebook only addresses the issue of standing. The majority also held that the EPA should address the rulemaking petition on the merits or supply specific statutory reasons why the proposed rules were inappropriate. This issue also broke 5-4 along ideological lines. Eventually, the EPA did issue a number of rules relating to greenhouse gases. The Clean Cars, Clean Trucks, Clean Power, and methane pollution standards, all adopted during the Obama administration. These are among the regulations President Trump's EPA administrator, Scott Pruitt, questioned before his resignation on July 6, 2018. What does this additional background about the Massachusetts v. EPA case suggest about how questions of standing in public interest litigation play into broader policy debates about big issues such as climate change and environmental protection? Can a judicial finding about standing or lack of standing in such cases serve as a proxy for more fundamental policy choices? What does the issue of standing in such cases say about institutional competence and power to decide the underlying policy questions? The Clapper case, summarized in the notes, has been important in my specialty of cybersecurity law. That case was brought by public interest organizations who claimed some of their members were adversely impacted by the bulk metadata collection instituted after the 9/11 attacks and disclosed in the documents released by Edward Snowden. This also was a 5-4 decision, with Justice Kennedy this time joining the conservatives. The note in our text summarizes how Justice Alito, writing for the majority, and Justice Breyer, in dissent, applied the doctrinal standing test to these facts. What other concerns might have motivated the split decision? Do you see any patterns emerging relating to judicial philosophy, political ideology, and standing doctrine? The most recent of our standing cases is Spokio v. Robbins, discussed in the supplement. Pause the video for a moment, surf over to spokio.com, and plug in a name to search. You can see that Spokio's service provides a variety of information about a person's financial status. Petitioner Thomas Robbins alleged that some of the information about him in Spokio's database was incorrect. His profile said he was in his 50s, had children, and had earned a professional degree. In fact, he was 29, single, and unemployed. It's likely that this incorrect information improved Robbins' creditworthiness, but he sued Spokio under the Fair Credit Reporting Act. The FCRA, originally passed by Congress in 1970, is enforced by the Federal Trade Commission, but also provides a private right of action. In relevant part, the FCRA states that any person who willfully fails to comply with any requirement of the Act with respect to any individual is liable to that individual for, among other things, either actual damages or statutory damages of $100 to $1,000 per violation, cost of the action, attorney's fees, and possibly punitive damages. Consumer protection statutes such as the FCRA often include this sort of dual enforcement mechanism. A government agency such as the FTC is charged with enforcing the statute through administrative fines and penalties and litigation. The agency has very limited staff and budget and cannot possibly police every violation. The statute, therefore, also includes a private right of action, often called a private attorney general provision. The problem here is that the value of any individual violation usually is so small that there's no incentive for a private party to file a lawsuit. These private attorney general provisions therefore often include provisions for strict liability, statutory damages, and attorney fee shifting. These features also make claims under such statutes amenable to class action treatment. A few claims worth $100 to $1,000 are not worth fighting over, but thousands or tens of thousands or millions of such claims on aggregate involve real money. As you can see, the court in Spokio, by a 6-2 majority, held that a statutory cause of action by itself is not enough to confer constitutional standing. Even if there's a statutory cause of action that provides for statutory damages, the plaintiff must satisfy the injury in fact requirement. On the one hand, this seems crazy. Congress created a cause of action for what the court terms procedural violations of the statute, so why should the plaintiff need to show more to get into court? This is essentially what Justice Ginsburg said in her dissent, joined by Justice Sotomayor. On the other hand, the majority noted that constitutional standing is a separation of powers requirement of the Constitution, which cannot be altered by Congress. Congress simply cannot create federal court jurisdiction outside the bounds of the Constitution. Again, think about these doctrinal questions in light of the underlying policy issues implicated in a consumer protection statute with a private attorney general provision. Is standing a proxy for policy decisions about the potential role of class action litigation as a regulatory tool? Incidentally, the Spokio case was remanded to the Ninth Circuit, which issued a subsequent opinion on August 15, 2017, holding that Robbins had demonstrated a sufficiently particular injury and therefore satisfied the requirements of constitutional standing. I also want to point out the summaries in the notes of Rains v. Byrd and Hollingsworth v. Perry. These cases address interesting questions about legislative standing and standing issues arising from direct democracy measures. Rains v. Byrd holds that individual legislators or groups of legislators who voted against a piece of legislation that ultimately was enacted into law cannot challenge the resulting law's constitutionality absent some other particularized injury. In such a situation, the losing legislator's remedy is to seek repeal or modification of the law through the legislative process. In Hollingsworth v. Perry, California voters had approved a ballot initiative that overturned a state Supreme Court decision allowing gay marriage in the state. The ballot initiative was challenged by two same-sex couples, and California's governor and attorney general refused to defend against this challenge. Voters who were proponents of the ballot initiative were allowed to intervene. The Supreme Court held that these voters lacked standing to intervene. Hollingsworth highlights some interesting problems that arise from state ballot initiatives, which bypass traditional concepts of representative government.